for Vancouver Kingston.
Thank you, Mr. Speaker. I am pleased to rise to speak to this very profoundly important bill that is before this House, Bill C-54, one that I think calls for all parliamentarians to reach deeply into their experience, deeply into their commitment to making good, sound public policy in this country, and that calls upon us to, I think, balance some of the most important values that we have as not only as parliamentarians but as Canadians. This legislation would amend the criminal code to create a process for the designation of not criminally responsible accused persons as high risk where the accused person has been found not criminally responsible of a serious personal injury offence, and there is a substantial likelihood for further violence that would endanger the public, or alternately in cases in which the acts were of such a brutal nature as to indicate a risk of grave harm to the public. Mr. Speaker, those designated as high-risk accused persons would not be granted a conditional or absolute discharge, and the designation could only be revoked by the court following a recommendation of the Review Board. It's important to note that this designation would apply only to those found not criminally responsible and not to persons found unfit to stand trial. The proposed legislation outlines that a high-risk accused person would not be allowed to go into the community unescorted, and escorted passes would only be allowed in narrow circumstances and subject to sufficient conditions to protect public safety. Also, the Review Board may decide to extend the review period for up to 3 years for those designated high risk instead of annually. The high risk NCR designation would not affect access to treatment by the accused. Mr. Speaker, this bill would also speak to the very important role of victims in this important matter. These changes would ensure that victims are notified upon request when an accused that has been found guilty of a non-criminally responsible or receive a non-criminally responsible designation is discharged. It would allow non-communication orders to be issued between the accused and the victim, and finally would ensure that the safety of victims be considered when decisions are being made about an accused person. Provisions in the proposed legislation would also help ensure consistent interpretation and application of the law across the country. These proposed reforms would not change the existing criminal code eligibility criteria for the exemption from criminal responsibility on account of mental disorders. Mr. Speaker, this is a very difficult issue for victims, families and communities. I would say it's a very difficult issue for all of those involved in the criminal justice system, from the police to the prosecutors to the defence bar to the judiciary. The public safety must come first when complying with the rule of law and the Canadian Charter of Rights and Freedoms, but it calls on very important balancing to be done. A number of recent cases that received significant media attention in Canada raised questions about the appropriateness and effectiveness of the current approach. In particular, we want to know how we can help victims better in the process and deal sensitively, fairly, and effectively with not criminally responsible offenders. In the coming weeks, we New Democrats want to talk with mental health experts, victims, members of the bar and provinces to find out what they believe is the best approach. It is important to note that we New Democrats do not want to play political games with this file. We must focus on the policy's merits and the serious issues that are involved in this matter. Mr. Speaker, I want to talk about some things that I think jump out as inherently positive from this bill. First of all, public safety as a paramount consideration, I think, is important to note. Second, increasing the involvement of victims in the process, I think, is something that will find favour on all sides of this House. The ability of victims to be notified, to have non-communication orders issued, and to have their own safety be considered in all matters affecting a not criminally responsible offender, I think are all laudable goals. I think it is positive to have review boards to have the option and not the obligation to extend the time for review is something that I think will extend the efficiency of our system. But I think that it's important to note that there are important causes for concern and pause here. This bill proposes that there be a limit to the number of community visits for high-risk accused. That introduces the concept of having mandatory minimum approaches to this area of the law that I think is so typical and characteristic of the Conservative approach to crime, and which study and statistics and experience of jurisdictions around the world have shown to be such an utter failure. I think there's also a legitimate concern about charter compliance and, very importantly, unjustifiable stigmatization of those with mental illness. Now, Mr. Speaker, I want to address something that I think the Minister for Natural Resources mentioned a couple hours ago, and that was the fact that a very sizable proportion of offenders who get an NCR designation had some experience with the law prior. In fact, a very sizable percentage of those people had been incarcerated before. So I think it's very important for us to note what kind of assistance is available to people with mental health issues in the current federal justice system and the penal system, and what is the Conservatives' record on dealing with those people who have experience with our criminal system before they get an NCR designation. Mr. Speaker, we did a report in this Parliament in 2010 in December on mental health and drug and alcohol addiction in the federal correctional system. And in that report, Mr. Speaker, after exhaustive study across this country, visiting some 20 federal institutions, hearing from all kinds of witnesses, we made 71 recommendations to this government to deal with mental health in our prison system. Those recommendations to the very people whose mental health issues first emanate in our system and who end up getting NCR designations in many cases. And here are some of the things we recommended. That the federal government, in cooperation with the provinces, make a commitment to and a serious investment in the mental health system in order to ease the identification of and access to treatment for people suffering from mental health addictions before they end up in the correctional system. Recommendation 3, that the federal government work with provinces and territories to ensure that police officers, Crown prosecutors, and other key players in the criminal justice system be trained to recognize the symptoms of mental health problems, mental illness, and drug and alcohol abuse so that they can direct offenders to the appropriate treatment services. Recommendation 4, that the federal government work with provinces and territories on early identification of mental health and addiction issues affecting offenders in remand and secure access to treatment services to them in order to address conditions that are so often precursors to escalating crime and incarceration. Recommendation 5, that the federal government support the creation and funding of more drug treatment courts to divert offenders with addictions to treatment centres and mental health courts to divert those with mental health needs to appropriate services. That the Correctional Service Canada work towards a psychologist-patient ratio of no more than 1 to 35 at all federal institutions. That was evidence received from the Psychologists Association of this country. That Correctional Service Canada add psychiatric nurses and plain nurses at every federal institution. That Correctional Service Canada place a renewed focus on individualized treatment for all offenders with diagnosed mental health conditions, including addiction issues. That Correctional Service Canada cover the cost of medication prescribed to treat mental illness of offenders on conditional release in the community through warrant expiry. Mr. Speaker, those are just a handful of the 71 recommendations that we made 3 years ago to this government. And do you know how many recommendations the Conservatives have put into practice? Not one.
Shame.
Not one of 71. But the Conservatives stand in this House when there is a serious media story of someone who finally commits a serious act, someone who's been involved with the correctional system, and they want to pass a law that deals with the aftermath. Well, here's the difference between the New Democrats and the Conservatives, Mr. Speaker. New Democrats want to work to prevent that crime from happening in the first place. New Democrats care more about victims than the Conservatives do, because we want to make sure that there are no victims in the first place, instead of trying to deal with the aftermath, the shattered lives of victims after those crimes have been committed. The New Democrats will actually put money and resources into the system, unlike the Conservatives. Instead of chasing cheap headlines and cheap answers that don't work,
so that we'll put the resources in so that actually people suffering from mental health in this country get the treatment that they deserve that'll keep them out of the penal system, out of the courts, and most importantly, keeping our communities safe, Mr. Speaker. That is a sensible approach to mental health in this country. That's a sensible approach to dealing with people in the criminal justice system. It's the only way we're going to make the public safe in this country. That's the New Democrat way, Mr. Speaker. Thank you.